Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Good evening and welcome into the attorneys. Thank you so much for being with us on this Sunday evening for the next half hour. Our topic of conversation, car accidents, and we'd love to have you involved in the whole process tonight. The way you can do that, you can call, text that information there on your screen. Also, attorneys from Hollis Wright standing by live right now to speak with you, and they'll be there throughout the entire show tonight. So if you get a question pops into your head and you'd love to speak with an attorney about it tonight, you have the opportunity to do so. Leading our conversation from the firm of Hollis Wright, managing partner Josh Wright. Good to see you once again, sir.
Good to see you, my friend.
Just the two of us tonight.
I like that. Just the two of us.
That's right. That's a song. That doesn't happen much, but this is a topic of conversation that you have a great deal of experience in.
Well, I think that's right. You know, my goal tonight is to talk about kind of the 101 of, or the 411, if you will, of what do you do if you've been involved in a car accident. A couple interesting statistics. The state requires you and I and everybody that's watching to have liability insurance at the very minimum of $25,000 in the state. 20% of the drivers on the road still to this day do not have that type of coverage. So one of the things we're going to talk about today is what do you do in those circumstances where you're hit by a driver that did not have the appropriate coverage? Is there things, or are there things that you can do to protect yourself? We'll talk through that and just kind of the 101 of the whole car accident area.
You know, one of the things about the show, we get new viewers every week. Yep. So folks who maybe have never even seen a show that we've done on this. So let's start from just the basics. If you're in an accident, what is your advice to folks if they're in an accident?
Well, a couple things. Number one, you want to ensure and maintain that health and safety is number one, and that's not just lip service of being a lawyer. Right. You really want to make sure that everybody is properly handled from a EMS perspective by calling the police immediately. The fire department comes there, EMS comes there, and you want to make sure that you're properly assessed. If you need to go to the hospital, go to the hospital. If you don't, maybe you don't. The reality is you want to make sure that's the primary thing that you do at the scene. You want an accident report. And the reason you want an accident report is not for litigation purposes. You want an accident report more than anything because your insurance company will use that, or the insurance company for the party that caused the accident will use that to be able to assess certain positions, determine whether or not it's a covered claim or a non-covered claim. So that accident report is pretty important and pretty critical. And the third thing that you want to do is gather information at the scene to the extent you can. And if you can't, follow up with the officer that worked the accident so that you can gather that information, like insurance and exchange insurance information, like making sure that you take pictures at the scene to the extent that you have the ability to do that, or somebody does that. Because those things go away over time. And if you don't get to counsel early and quickly to let them manage those things, sometimes you lose witnesses, you lose vehicles because they're salvaged, and you lose information necessary to be able to present a claim.
You're a young fella, but you, in your legal career, the number of cases relative to this subject matter that have crossed your desk, they're going to number in the thousands now. What is the most common mistake that you see clients and potential clients make relative to car accident cases?
I think delaying in getting somebody that knows what they're doing involved. A lot of times, and there's no problem with this, but it doesn't work out great that often. A lot of times somebody will be involved in a car accident and they say, well, I don't want to go pay a lawyer a contingency fee to represent me and present the claim. I think I can do this on my own. Right. The reality, David, and this truly is not a request for people just to come to our law firm. There are a lot of great car accident lawyers out there, but you need to get to somebody. You need to get to somebody quickly, and here's why. Couple important points. Number one, the lawyers know what information, documentation, and evidence you need to present your claim to maximize the claim more than you do, because this is what they do for a living. Number two, they'll handle cases on a contingency, which means they'll spend all the money and resources to download black boxes to determine how fast people were going, to get experts involved, maybe that were accident reconstructionists that can reconstruct the accident because maybe somebody lies about what happened in the accident. You want lawyers involved because they can get things rolling quickly. And they'll do it on a contingency fee, which in essence means you pay nothing ever until there's success in the case, and only if there's success in the case. So if it turns out it's a joint accident and it's partially your fault and you're prevented from recovering, the lawyer may eat the entire cost associated with helping you gather the information and documentation and whatnot that you needed for the accident. The third thing that I think is super important is this, and this is just a fact. There are statistics out there that will indicate that the individuals who hire lawyers get a larger result from insurance companies than those that try and go it alone. I can tell you anecdotally that's true. I can tell you in practice it's true. I'm not going to give you a statistic as to the increased value, but what I can tell you is this. A lot of times it is marked and significantly greater if you use a lawyer, and the lawyer pays for himself with his contingency fee based on what you could get alone. And again, I say this each time, and I really mean this. It's not just lip service. You don't have to come to our law firm. You know, there are a lot of awesome lawyers out there that handle this kind of stuff, but you need to get to somebody because I do think that they can help and protect you.
Right. Question we've got here, if I think the accident is my fault, should I tell the police officer that?
Well, you know, I think the officer's role, and it's a good question, the officer's role is to gather information, and they're probably going to want to talk to the witnesses, especially those that are involved in the accident, if they can, either in the hospital or at the scene. But it's his responsibility or her responsibility to properly evaluate and investigate the claim. That doesn't mean that you need to tell them that it's your fault. It may not be your fault. You may think that it's your fault, but allow the officer to do their job. Here's the other thing. In Alabama, super important. In Alabama, to the extent that you contributed to your own injury in some respect, even 1%, you're barred from recovering. There are a couple exceptions to that, but you're barred from recovering. Another reason why you want to get counsel involved early so that you can lock those things down before you provide witness statements, for example, to the insurance company, and even in certain circumstances to the officer. I know we're getting ready to go to break. I want to talk about what happens when we get back. I want to talk about what happens when you're hit by somebody who doesn't have insurance. Do I still have recourse and a potential claim? And we got some good answers for that.
Good deal. We'll get into that whenever we come back. As we head to break, a reminder, the firm of Hollis Wright, awfully active on social media. You'll find them on Facebook. Just search that term, and Twitter, Hollis_Wright. Stay tuned. We've got more of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Welcome back into The Attorneys, talking all about auto accidents and everything you need to know. We'd love to have you join the conversation. That information you see there at the bottom of your screen all throughout the show. Josh, when we head to break, you were talking about what happens if you were hit by someone who was uninsured. That's kind of that's a scary proposition, and a lot of folks fear. What's the course of action there?
Well, you know, you saw the firm fact coming in, David, and it is that everybody's supposed to purchase liability insurance. Everybody in the state, there's a state statute that requires that. When you sign off on your license when you get it renewed, you're supposed to confirm you have insurance. If you're pulled over, you're supposed to provide proof of insurance. Unfortunately, and we see this all too often, roughly 1/5 or 20% of those on the road today do not have liability-related insurance.
What's that percentage again?
20%.
Oh, wow.
20%. That's a huge percent.
Yeah, it is.
And so there are things that you can do to protect yourself in circumstances where someone does not have liability insurance. And I'll give you a good example. There is a part of your contracting with your insurance company, there's really, if you will, 3 or 4 components. One is liability. That is, if I'm operating my vehicle and I cause an accident to somebody else, am I covered and protected so that that person can be reimbursed and compensated for their injury? That's called liability insurance. There is what's called comprehensive insurance, which is a tree falls on my vehicle or somebody hits my vehicle in the road and they run, they leave, and we don't know who they are, or there's some other damage done to my vehicle while it was in the garage, whatever that issue may be. That's comprehensive coverage that generally will cover your vehicle, and your loan officer, for whoever you have your vehicle through, generally is going to require you to have some form of that. Then there's also property insurance, which is if I cause injury to someone else, I've got liability insurance, which is required by law. Property insurance also is to protect in circumstances where I've caused property damage to somebody. So I'm going to reimburse their vehicle, not just their person, but their vehicle. There's also a 4th component that people don't really talk about a whole lot and don't know nearly as much as the other 3, and that's called uninsured motorist coverage. What I call this, and the way I would explain it to somebody, if you were in my conference room and they were asking about, what kind of coverages should I have, uninsured motorist coverage is rainy day coverage. You pay for it to protect yourself and your family and those that live in your household in circumstances where somebody either has insufficient insurance to compensate you for your loss or has no insurance to compensate you for your loss. I'll give you a hypothetical or an example, okay? Let's assume that somebody injures me and I end up with a back surgery that cost me $50,000. I was not injured in any fault of my own, except for the fact that I was hit by somebody who was negligent, okay? And they have $25,000 worth of coverage. I'm going to get that $25,000 worth of coverage, but I still owe an extra $25,000 for my medical care, right? That medical care that gap can be filled by my uninsured motorist coverage, which steps in and protects me in that circumstance. That's a very simple example, but the short of that is if somebody has no insurance or they have limited insurance, uninsured motorist coverage is super important to use. And I'd mention 2 final things related to that. Not getting preachy here, but it's an important concept. Number 1, buy as much as you can get. It's not expensive. It is the cheapest of all the coverages. Buy as much as you possibly can get to protect yourself, your family, and those that live in your household. Number 2, and a super important component to this. Generally, and I say generally, there are some exceptions, David, but generally, if you are not the cause of your accident and you make claim to your uninsured motorist coverage, okay, so somebody caused the accident, they either had insufficient or no insurance, and I'm the one that has to pay with my own insurance, generally it will not impact your insurance premiums. Generally. There are a couple exceptions to that, but generally it won't. So that insurance is super important to protect you.
Yeah, boy.
I know that was that's a long answer for that, but it's an important topic, and we've done shows just on that alone.
And it's really surprising, maybe you've said that statistic before, but 1 in 5 motorists are uninsured out there. Think about
and
that.
I get a lot of questions from clients. Are they not going to be criminally prosecuted for this? And unfortunately, the court systems are so overworked. Doesn't mean they're not doing their job. It's just they're so overworked. Law enforcement's overworked. The district attorneys are overworked. Prosecuting people for failure to have insurance is a really tough proposition. It does happen, and people get fined for it, but it's not something that's significantly prosecuted.
On the subject matter, while we're talking about insurance, a question we've got here: do I have to report the accident or an accident I'm in to my insurance company? Is it required? Is it a must?
Yeah. So I would assume the answer, and I'll tell you why I'm going to say this. If you're in an accident, whether it's your fault or someone else, assume you have a duty to do it. There are a couple exceptions where you don't have to report an accident. However, assume you do, and here's why. Most insurance policies have a requirement that you provide notice so that they can investigate on your behalf, because they think, the insurance company thinks that they can investigate more efficiently than you can. They have more resources to do the investigation. And I get that and I respect that. And I think generally that's what they'll do, is go out and investigate it. If you fail to notify your insurance company, especially in circumstances where it's your fault, you could have a denial of coverage down the road under a certain time frame. So here's the general rule. General rule is assume for purposes of the contract you sign that you have a duty to disclose it, even if it's not your fault. If nothing else, it doesn't hurt you to disclose it, right? If nothing else, disclose it so they're on notice of it, let them start their investigation, and then it can go from there.
On the subject of insurance companies, another question we've got here, should I talk with the other driver's insurance company?
So there are a couple thoughts on this. One is a lot of lawyers will tell you absolutely no, under all circumstances. You need counsel to assist you and kind of direct you and prepare you for those statements. I would say this, there are certain circumstances with minor fender benders where it is simply a property dispute without personal injury, where I don't think it's appropriate, and I don't think it's terrible advice to say it is okay to talk with the other insurance company for purposes of resolving a property-only dispute. You need to know when you do that that the other insurance company is going to try and do some things, if they can, to reduce the total amount that they owe. For example, if they can show that the person who assumed that they were the victim had a contribution to that accident because they contributed in some way, they've got a stronger argument to lower the property value. But in general terms, especially when there's personal injury, you need a lawyer involved. We've already talked about that at the beginning of the show, why a lawyer is more important in these cases. But if you have got a liability-based injury where you are hurt and you have an injury, whether you have counsel or not, do not give a statement to the opposing insurance company unless you talk with a lawyer first. One last thing, and I know we're getting ready to go to break. If you're injured in an accident and your insurance company calls to give a statement to them, meaning your own insurance company calls you, you generally have a duty to provide a statement to them. But again, I would get a lawyer involved, if nothing else, just to get advice on, is this a good idea? Can you help me get prepared?
So just that scenario, out of the blue, I get a call, I pick it up, I've been in an accident, it's the other insurance company. So I can say to them, I'd rather not say anything right now until I speak with my attorney, and
100%.
we'll be in touch. 100%. That's all commonplace and normally done.
Very commonplace,
Okay.
100%.
Okay, all right. We're stepping aside.
Yeah.
Our final break of the evening. We're heading to break here. As we do so, a couple of reminders. We'd love to have you join our conversation here. There's how you can get in touch with us. Also, the attorneys from Hollis Wright standing by live to speak with you right now. Take advantage of that opportunity. Stay tuned. More of the attorneys coming right up.
I'm Tyler Vail with the law firm of Hollis Wright. In court, attorneys are not allowed to tell juries certain things. For example, we cannot talk about a defendant's net worth, meaning the defendant's ability, resources, or insurance to pay a verdict. In this week's Legal 411, we're answering the question, why can't lawyers talk about a defendant's net worth to a jury? Rule 403 of the Alabama Rules of Evidence states, although relevant, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Long-standing Alabama cases have held that the net worth of a defendant falls under this catch-all rule. The reasoning behind the rule is that if a jury knows a defendant is wealthy, then the jury might award more money to the plaintiff. And this goes one step further. If an attorney makes any remarks that suggest the defendant is responsible because he is rich and the plaintiff is poor, that can be grounds for a new trial. If you're ever on a jury, the reality in our state is this. In almost every lawsuit that goes to trial, the attorneys representing both the plaintiff and the defendant have already looked at whether there is sufficient insurance coverage or assets to satisfy a verdict. The reality is this. The parties would not pursue a civil lawsuit if damages could not be paid after a jury returns a verdict. So even though lawyers cannot mention the net worth of a defendant during a trial, there could still be resources available to pay a verdict in court. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you.
Welcome back in to the Attorneys Hour, final segment. Time just seems to fly here on the show each and every week. Don't forget, the attorneys from Hollis Wright, they're standing by live, but only for a few more minutes. So if you'd like to take advantage of that opportunity to speak with them, pick up the phone and give them a call. So many questions, so little time. Let's jump right back into this, Josh. So how long do I have a couple of kind of going to combine two questions here, but how long do I have to make a uninsured motorist claim, the UIM claim, and a liability claim? How long do I have there? So in terms of timeliness.
Yeah. All right, so you hit me and you have insufficient coverage. When you hit me, I got 2 years to file suit against you.
Okay.
If I want to get to my own uninsured motorist, I'm probably going to have to file suit against you, or I'm going to have to reach a deal with my UIM carrier. But I got 2 years to file if you hurt me.
Right.
But against my own UIM coverage, if they don't do the right thing, don't compensate me based on my uninsured motorist or underinsured claim, you generally have 6 years because it's a contractual claim you have with your own insurance company. So to put it really simply, if somebody hits you, you got 2 years to file that suit. 6 years against your own carrier.
Well, why would someone wait that long?
They wouldn't have to. It falls under the general 6-year contract statute of limitation where people have 6 years if somebody doesn't perform on a contract to file that suit. Mm-hmm. Like I mentioned earlier, I wouldn't wait that late.
Right.
Things get stale,
yeah,
things
exactly.
go away, witnesses go away. Mm-hmm. Your ability to be successful in a claim when there's stale justice because the case becomes stale gets more difficult. At the end of the day, I am a big advocate, whether it's us or someone else, go find counsel early in these cases because there are things that you need to preserve, whether it's the officer's statement, whether it is a police report, whether it is skid marks, whether it is an accident reconstructionist, a black box download, statements from witnesses, whatever it may be. We want to get moving on that as quickly as we can to make sure that we're protecting the interests of the client who wasn't injured at any fault of their own.
Someone wants your opinion of taking pictures at the scene. Everybody has a cell phone, so it's easier than ever. You advise that?
Absolutely. It's really been awesome through the totality of my career from roughly the 1998 time frame. I'm at 20 years now. The lawsuits that I had early on, very seldom were there pictures ever taken at the scene of accidents other than through police officers or through tractor trailer companies that may be doing an investigation on the scene. Now it is so commonplace to not only get pictures, but to be able to ask a witness, hey, I noticed you posted this on Facebook. Mm-hmm. You obviously saw this accident. Can you send me your photographs? It's the technology gap has closed, and now technology is involved in almost every case that we have. The answer to your question is yes. I would highly advise if you can or have someone take pictures at the scene. It's very helpful to identify kind of the circumstances of where the vehicles were at the time of the accident.
Mm-hmm. And easier than ever to do. A question here about seatbelt use and wearing a seatbelt. What if I wasn't wearing my seatbelt? Does that mean that I don't have a case?
No. Generally, seatbelt use is not something that is admissible to establish whether somebody was liable or not liable or whether they contributed to their own injury. So the general rule is seatbelt use is generally not admissible in a case. There are some exceptions, and I don't want to make it sound like seatbelt use never matters. Right. Give you an example. In an automobile product liability claim where seatbelts interact and work with airbags and side curtain bags and other restraint devices, if you don't have your seatbelt on and those things can't work in tandem with one another because it expects you're going to have your seatbelt on for all of it to work correctly, seatbelt use could be applicable and could be relevant in the case. But in a typical car accident, trucking case, you're generally not going to hear anything about seatbelt use.
Another question, what if the other driver's insurance company wants a copy of my medical records? Should I release them?
The answer is no. It goes back to the general rule. If it is a property-only claim related to damage to your vehicle and you don't have a lawyer involved, it's probably okay to communicate a bit with the opposing insurance company. If it is a personal injury claim where you are injured and have medical records and have a legitimate injury, it is not okay to communicate with the other insurance company, and it's unnecessary to do so unless you've got counsel on your side. So those are the general rules right there. If it's property only and it's just property, you probably can communicate a bit with the other side. If it's personal injury and you've got some injury, don't communicate with the other side and don't provide medical authorizations, because they can go get your entire medical history that may not even be relevant to the accident or the injury.
I was watching a fellow partner of the firm, Bell, 411. He had an informational, educational piece just about some tips if you've been in an accident and interacting with an insurance company. Something that he said that I've never thought about was warning against getting new friend requests on Facebook, what you post on social media. You say often, most insurance companies do it well, do it right, but might those in your social media use and that sort of thing, should you kind of watch out for that sort of thing?
100%, and it's a great point, and here's why. In Alabama, we have a rule that if you contributed even 1% to your own accident or your own injury, you're probably going to be barred from recovering. There are a couple exceptions to get around that. But if you're even 1% liable, so two people run the stop sign, one person's 99% responsible, one person's 1% because they could have stopped in advance, you may be barred from recovery with a couple exceptions, okay? And with that, liability-related issues, if you post on social media what happened in the accident, whose fault it was, that you're sorry for what happened on your end, those things can all be used against you. The same thing is also true with reference to your injuries. Right. Depending on what you post, a lot of people are go-getters, and they're like, I'm not injured, I'm never going to be injured. I had that neck surgery from that accident, but I'm doing just fine. Well, that's all good. And you know what? Juries like go-getters. They don't want people just to quit in life. So I like the go-getter client. But be careful what you post, because it's going to be used against you one way or the other.
Yeah, be smart about it. Believe it or not, I only have about a minute and a half remaining, but want to give you the opportunity just to give our viewers tonight just a final charge and final thought from you.
Well, you know, I am a big believer that lawyers have a super important role in litigation-related issues and in accident-related issues. I have based my career, my practice, my family's livelihood is based on something I'm passionate about, which is helping people at moments where they have been injured and they've done nothing wrong. And those are the folks I like to help in life, and there's nothing wrong with that in my mind when I'm out there advocating for those folks. They need to get lawyers involved, and we say so many times, and it sounds almost like it's just a buzz phrase, but I don't mean it as a buzz phrase, and I say it genuinely and honestly, and that is this. You know, you don't have to come to us. There are a lot of great firms out there, but go to someone, get legal help. You can do it on a contingency fee where you may have no cost whatsoever to litigate and get the same quality of service that you otherwise would get on the defense bar. So come to a lawyer early.
Awesome show. Appreciate the opportunity. Just the two of us.
Always good to see you.
Appreciate that. Josh Wright, also want to thank you so much for being with us each and every week. Thanks so much. As we head to break, here's how you can get in touch with the firm. Available 24/7 there at hollis-wright.com. Stay tuned. See you next week is what I'm trying to say. We'll see you next week right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.